vacation. Okay. The prayer made by and counsel for the petitioner list on 15/10/2025. Yes.
Oh, bless you.
15.
Yes, Doctor.
You want an adjournment?
Yes, Doctor.
Okay. 2019 matter. 27/10.
May I please your Lordship? Lordship, I am ready for the of the lead petition on.
Yes.
Lordship, you mentioned for listing.
Listing gave it to the courtmaster.
That's the minute. It was fixed on 27/10.
There may be 101 good reasons. Please give it to the courtmaster. If you want to really make submissions, that at 4:30.
Sure.
Daily list item 2 with 3.
Please. Persons who are
Yes.
detention, Malad. They were on bail and they were picked up thereafter the detention camp.
Yes.
Lordship will ask them to file an affidavit. They said below the affidavit, page 45, that they are being kept in the detention center for some factual and documentary verification. That is the second stage.
Just a moment. Page 45.
Page 45. Has initiated the process of deportation of declared foreigners, the declared director of the central government. The declared foreigner named is Spencer has been picked up and kept in the holding center for some factual and documentary verification of the government. Once the verification is.
Yes. What is the present status?
Lordship. Lordship, kindly give me 1 or 2 days time, Lordship. I'll.
I'm just a bit confused. This item number 2, pursuant to this, the husband's Vakaratma was taken and therefore this second petition is filed.
No, madam.
What are these two?
These are with regard to the detention, madam, where the petitioner.
No, they are two separate persons. Is the detained person separate or same person?
No, they are two different, one is different.
Different.
One is Milord,
Acha, acha.
wife is filed on behalf of Majibar Rahman. And 3 is Milord, Saniful State is filed on behalf of his father Abdul Sheikh. Two different.
Okay, okay. We thought there was some relationship and therefore we are confused. Okay. Okay, similarly placed, so they are together.
Yes.
Okay.
Lordship may fix it on Monday, Lordship. I will provide the present status.
Okay. Heard Mr. M. Dattalan, counsel for the petitioner, as well as also for the respondents. The this item number 2, it is the husband of the petitioner, namely, Majibur Rahman, alias Majibur Sheikh. She's the wife.
Husband.
Majibur Sheikh, page 5, paragraph 2. Is was apprehended on 25/5/2025 and as disclosed by the learned standing counsel for the FT matters on the earlier occasion, he is presently lodged in the holding center under 7th APBN, Saraikola, Praja. In terms of the disclosures made by the respondent number 2 in the affidavit in opposition filed on 16/7/2025, the respondents are put to notice to address the court on the justification of continued detention of the petitioner, petitioner's husband on the next date of listing. Next list on 22/9/2025. And in the second one, the petitioner, the detained person's
Is the son, sorry, father.
father. Okay,
Picked up on the same day.
father,
Here no affidavit is filed, they took a stand, they'll be relying upon this affidavit.
the father of the petitioner, namely Abdul Sheikh. Same date. Abdul ABDUL SHEIKH. Okay. Mr. Datta, since this is motion column, we're taking it up in admission. Because at motion, we have some difficulties. Next, in the meanwhile, the court is inclined to issue notice returnable on 22/9/2025 without requiring any fresh steps to be taken list in the admission column on 20 to 9/2025.
Item 4.
May I please the lordship? Challenge the including order declared May 2023.
Opinion is which page? Opinion in which page?
Lordship, page number 90 and operative part is 100 lordship.
90 is 22. You have to wait for some time for bail. Your name?
ARM Sheikh.
A. Alim Sheikh. And counsel for the petitioner. Responsible for the respondents. Page 90, opinion dated 8/2/2022, passed by so and so and so and so. By declaring the petitioner to be a foreigner of post. He is an illegal migrant of post 1971 stream. Notice extra copies within 2 days. Call for the records from the concerned tribunal at the following email address. If prayer for bail shall be considered on receipt of records. In the meantime, if the petitioner, namely so and so, is apprehended, I shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of the certified copy of the order before the Superintendent of Police Border,
Baksa.
Baksa. Bring the order to the notice of the said authority.
Not to deport. Be accepted.
Okay.
Yeah, deported.
Item 5.
The interim order here is on page 64. 64, Your Honor. What is the 2019 matter?
On the next sheet, you'll have to address us on the issue of maintainability.
You are Mr. Ayusin. Mr. Ayusin for the petition and counsel for the petitioner has assailed the opinion dated 13/5/2019, page 64. Issue notice. Extra copies within 3 working days. Issue notice keeping the issue of maintainability. Correct. Open. Extra copies within 3 days. In the meantime, he shall appear before the HP border. Sorry.
Can be the same.
1710.
Your lordship, in this matter, I will produce a copy of the order before that.
Yes, yes, that's good.
Lordship.
Item 6.
Yeah, no.
After receiving the notice, appeared and published, then evidence was also, evidence issue was filed. Then my lord, lockdown came. After lockdown, it some miscommunication with the lawyer, and in fact, the lawyer has left the profession. All these reasons, my lord, there was some date he was absent. And ultimately, the court, the learned tribunal had passed the order in expert. He could order at this committee.
Yeah, left the profession.
I left the profession.
Where do you find that? But then we won't put that, what you call, issue of maintainability will not mention in the order. We're asking you this because of page 60.
My lord.
Para 20, page 11.
Page 60, second last date, 2012-2021.
It also not completely put the cards on bias. Para 20, that's it. Para 20, that yeah, it has left the profession.
Para
Paragraph 20.
20.
Yeah. They can't to be an activity, sir. Left the profession. Because of all this connection.
Yes, declare. Counsel for the petition also represents with this writ petition under Article 226 of the Constitution of India has been preferred challenging the ex parte opinion rendered on 21/2/2022 passed by the Foreigners Tribunal number 1, Nagaon in FT case number 57 of 2018. The learned counsel for the petitioner has submitted that on the issue of maintainability of the writ petition after such a long duration. The learned counsel for the petitioner has submitted that the counsel engaged by the petitioner before the learned tribunal had left his profession immediately after the COVID-19 period and had joined as a school teacher. And despite several attempts being made, he was not informed regarding the proceedings taking place in the learned tribunal. In view of the above, comma, after considering the objections raised by the learned counsel for the FT matters with regard to the delay, we are satisfied that the delay in the present case can be condoned. Full stop. Issue notice. Returnable. Extra copies within 3 working days. All for the PCR. The interim bill will be considered on receipt of the trial court records. However, it is provided that in the meantime, if the petitioner is apprehended, he shall not be deported without further orders of this court. Petitioner shall appear before the SP. Nagaon. SP Bhutan Nagaon. The certificate copy of this order. Considering
My lord, he may be detained, my.
that risk is there.
Then that means he may be allowed to go on bail, my.
Shall cause.
Fine.
You don't have to produce it. Someone from your family will produce.
My lord, police is very particular. My lord, he will insist on personal appearance because this order has noted, or in the order has been noted, my lord, his appearance.
No, but that is why it shall cause production of the order. In case he is apprehended.
My lord.
Mr. Sikdar, we will continue to make that same mistake. You will have to remind us to correct ourselves. Okay, cost production. Okay. Motion same date.
1710.
Nine.
Item 7.
Yes.
Yes, purpose petition, my lord. The mother of the petitioner was arrested on, my lord, 23rd of May, my lord, 2025, my lord. And since then we don't know about whereabout of her, my lord.
She was apprehended when?
She was apprehended on 23/5/2025.
23/5.
Yes, my lord.
You're too late in,
By Sibsagar police, my lord.
you're too late in moving the court. Monday.
But Mr. Zaid Ahmed, the counsel is paying for the petitioner, also has sense. This writ petition under Article 226 of the Constitution of India has been preferred by the petitioner alleging that his mother had been picked up, had been picked up by the police authorities of Sivsagar's Sadar Police Station on 23/5/2025, and thereafter her whereabouts is not known. The mother of the petitioner had been declared in page 30. Page 30 that you have given the order,
Yes,
the
yes.
the
The-
last lines are not appearing in that order.
I'll furnish a fresh
You
copy.
have to give up a
Yes.
fresh,
Mail.
file an additional affidavit bringing the
Mail.
entire order on record. Was declared as a foreigner who had entered India entered India after 25th of March 1971 from Bangladesh.
Page 30.
In view of the above, the learned spending council active matters is requested to obtain instructions as to the whereabouts of the mother of the petitioner. Download the PP. List on Monday. Second of September.
Mail.
This, Mr. Ahmad,
Yes, my lord.
this is passed by whom? Which tribunal? We can't get that name from page 30.
Yes, is the order, my lord, that I have received is in such a manner. Foreigners Tribunal, Jorhat, my lord, at page 32, my lord.
Page 32.
Yes, the bottom part, my lord.
Okay, Foreigners Tribunal, Jorhat. Huh?
Jorhat, my lord.
একদম উপর।
Okay.
Item 8.
Yeah, please, Lord. My lord, the impending opinion at page 80, my lord, 80.
You have to wait for some time for bail.
My lord.
Heard Mr. S. A. Ahmed, Rani counsel for the petitioner, also heard counsel for the respondents. The petitioner has received the opinion rendered on 21/2024. Rendered by the members, by the learned member, Foreign Tribunal, Jorhat, Assam, page 80. Issue notice. Returnable soon, so extra copies within 3 working days. Call for the PCR. Therefore, bail will be considered on the next returnable day, on receipt of the PCR. However, you have not been detained till now.
No, outside.
However, in the meantime, it is provided that if the petitioner is apprehended, he shall not be detained, he shall not be deported without further orders of this court. The petitioner shall cause production of certified copy of this order before the Superintendent of Police, Border, Golaghat. List on
17.
17.
My lord.
Item 9.
May I please, as your lordships? My lord, the grievance raised in this petition, my lord, is regarding the notice which, my lord, the petitioner has received. My lord, the grievance raised, my lordship, the prior to the issuance of the notice, the investigation and the procedural requirement, my lord, which is required to be done, has not at all had been followed, my lord. No, my lord, opportunity of hearing or the investigating officer, my lord, was never pleased to ask me for any documents to satisfy him. That, my lord, had that opportunity had not been provided me. That is the basic grievance, my lord. And my lordship is, my lord, knows, my lord, that the recently the Honorable Apex Court in the Rahim Ali judgment, my lord, has categorically dealt the same issue, my lord. Lord, just for a moment, my lord, if I may be permitted to draw my lordship's attention, my lord, to the notice, my lord. Is at page 14, my lord. My lord. Lord, those, that is, my lord. My lord, to satisfy the question put forward by my lord, my reply, my respectful reply before my lordship is that, Lord, when there is a procedure, a statutory procedure is prescribed under the 1964 order, my lord. My lord. No, my lord, the very issue, it is the issue of the, my lord, a person's citizenship issue is in question, my lord. My lord, a person, the honorable, my lord, just for a moment, my lord, if my lord allows me to draw a few paragraphs of that judgment of the honorable apex court, my lord, just for a moment. No, that is there, my lord, that is there. Sarvanan Sonowal 1, Sarvanan Sonowal 2, my lord, and the lastly, this, my lord, this Rahim Ali judgment is, my lord, I have gone through, but my lord, here is a case wherein the exact situation has been dealt with, my lord, exact situation. That's why, my lord, just for a moment, my lord. Huh? My lord, I beg to draw my lordship's attention, my lord, to paragraph 33. 34 can be is relevant, my lord. 34. My lord. My lord. My lord. But my lord, that is the issue, my lord. But here is an issue wherein the procedural safeguards which has been given, which has been prescribed for a proceeding, my lord, even the Muslim Mandal, my lord, the Muslim Mandal in our review judgment has also held that, my lord, the investigation and the trial is concomitant, my lord. We cannot segregate both. Now, before the trial, my lord, a fair investigation part is required to be followed. That has not been done, my lord. In my case, my lord. My lord. My lord. My lord.
IMDP.
No, that is correct, my lord. IMDP, when it has been strike down, my lord, IMDP has been strike down, my lord. My lord. Smaller ventures, my lord. My lord, I'm sorry, my lord, my wording is not proper, my lord. My lord. Yes, my lord, that by superseding that the full bench judgment, why this judgment is applicable or can be followed. My lord, the facts and the, if my lord, I can bring those judgment for satisfaction of my lordships also, my lord. My lord. My lord, But my lord, but my lord, just for a moment, if I may be permitted to read these two paragraphs, 34 and 35, my lord. It's very elaborate and connected with the present cause, my lord. 34 says, however, the question is that does section 9 of the Act empower the executive to pick a person at random, knock at his, her, their door, tell him, her, they, them, we suspect you of being a foreigner, and then rest easy basis section 9. Let us contextualize this to the facts at hand. The originating point of inquiry is the SPB Nalbari's direction to Sub-Inspector Datta on 12/5/2004. The pleading and the record are silent as to what? My lord. My lord, no, my lord, I have a very limited. My lord. My lord. My lord. My lord. No, my lord, that right absolutely have, my lord. The authority have. But when they are asking me, my lord, that question, that opportunity has not been provided to me, my lord. Behind my back, a report has been prepared and produced before the Foreigners Tribunal. That is the, my lord, larger issue, larger question is here, my lord. My lord, tomorrow I may be also a victim, my lord. If somebody comes. No, my lord, my lord, I am just giving an example by citing myself, my lord. My lord, that is the trend going on, my lord. That is the even my lordship is well aware. An army officer has also been questioned. He do not know about his, my lord, when the investigation was conducted. Recent case, my lord. So therefore, my lord, the procedural safeguard which has been provided in the 1964 order regarding the notice part, my lord, along with the notice, the grounds, the documents which are required to be annexed. My lord. No, my lord. My lord. Then my lord can fix this matter after the vacation, my lord. Regarding the issue, my lord. But my lord, a person has been, my lord, branded, suspected to be a foreigner. Suspected, and that suspicion ground material, my lord, satisfaction, nothing is there. Just a notice has been presented to a person. You have been suspected, you come and satisfy at the trial stage, my lord. But the judgment says it should start from the investigation stage, my lord. That opportunity had not been provided, my lord. That is the basic grievance of the petitioner, my lord. My lord. No, Sarvananda, my lord, that is. My lord. On the accused, my lord. My lord, my lord. 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 Giving. Oh, my lord. Okay, my lord. As a bad gesture, my lord. Bad, my lord. My lord. My lord, my lord. My lord. Going on, my lord. My lord. My lord. Correct, my lord. Lord, if I cannot satisfy my lord, my lord, then my lord can. My lord. My lord, my basic, I inspired from the judgment of Rahim Ali, my lord, because, my lord, what I respectfully beg to submit before my lord is that, my lord, Sarvananda Sunwal 1 and 2, both deals with, my lord, the virus of that IMDT Act, my lord. And while discussing with the virus, my lord, the external aggression issue is there, my lord. That is no doubt. External aggression and the report of the Honorable Governor had also been considered, my lord, while, my lord, delivering the judgment. Now, my lord, but those issues, but that judgment, my lord, has never touched upon these procedural safeguards of 1964, as well as the other issues of the principle of natural justice has not been touched. So, therefore, my lord, as that issue has not been, my lord, dealt with by the larger branch of the Honorable Apex Court, my lordship can always examine, my lord, that whether these procedural safeguards for this type of person is applicable for my lord. My lord. My lord. My lord. Yes, yes, CPC, my lord. My lord. My lord. Finding by the tribunal, my lord. No, tribunal has already, my lord, take the cognizance. Once the cognizance has been taken, my lord. My lord. In the WS, my lord. My lord, my lord. My lord. My lord. That can be done, my lord. But the issue is that, my lord, as we have raised the preliminary, my lord, maintainability of the notice. My lord, I can understand, my lord. I can understand, my lord, the issue, my lord. No, no, my lord, POXO is a different, my lord. My lord. My lord. But here says, my lord, that first you follow the compliance of the notice part, then the presumption and burden will shift to the proceeding. That is the, my lord, finding of the Honorable Apex Court, my lord. My lord. Yes, yes, my lord, 34 and 35, my lord. 35 says, my lord, first, it is for the authorities concerned to have in their knowledge or possession some material basis or information to suspect that a person is a foreigner and not an Indian. In the present case, though it is not mentioned that from inquiry it was revealed that the appellant had migrated illegally to the state of Assam from Bangladesh after 25/3/1971, but nothing has come on record to indicate even on iota of evidence against him, except for the said allegation that he had illegally migrated to India post 25/3/1971. It is also not known as to who, if any person had alleged that the appellant had migrated to India after 25/3/1971 from village so-and-so, police station so-and-so, district Moimonsing in Bangladesh. It needs no reiteration that a person charged or accused would generally not be able to prove to the negative if he/she is not if he is not aware of the evidence/material against him/her, which leads to the person being labeled suspect. Ipso facto, just an allegation/accusation cannot lead to shifting of the burden to the accused unless he/she is confronted with the allegation as also the material backing such allegation. Of course, at such stage, the evidentiary value of the material would not be required to be gone into, as the same would be done by the tribunal in the reference. However, mere allegation, that too being as vague as to mechanically reproduce simply the words which mirror the text of provision in the Act, cannot be permitted under law, even for the person to discharge the burden statutorily imposed on him by virtue of Section 9 of the Act. The person has to be intimated of the information and material available against him/such that he/she can contest and defend the proceeding against him.
Mr. Bhuya, tell us one thing.
My
Page
lord.
24.
Of my,
Page 24, yes.
my lord.
Paragraph 17. Eighth line from the below.
My lord. That the principle of natural
No,
justice,
you come to the eighth line from below.
8 line, my lord.
Starts with the word produce some documents. Produce the some.
Inquiry officer asked the petitioner to produce in respect of his, however, the petitioner could not produce the same, therefore he had been suspected to be an illegal migrant.
Now, we stop, we pause there for a moment.
My lord.
This apparently is not a case where the referring authority
My lord.
has knocked on his door, or the tribunal has knocked on his door
My
to
lord.
say that please, we suspect you. No. Here, what we see is that the petitioner was required to produce papers. He
My lord.
was not given sufficient time, is the allegation,
My lord.
and therefore he was suspected to be a foreigner.
My lord.
Now, all that remains to be done is he produces before the tribunal
My lord.
that I did not have time there. Now I have.
I have time.
Matter is over. It is not a case where
My-
someone from the road is picked up and a notice is given to him. No. He was asked for documents, he could not produce it.
My lord.
Whatever be the time frame. For someone, it may be a 1 day time, for someone, it may be a month's time.
My lord.
But he could not produce it before the inquiry officer in the given time. Whether the time is short or not short, whether it was sufficient or not, whether the documents are there or not, this has to be done before the tribunal.
Allegation is investigate. My lord, may kindly, my lord, my instruction is that, my lord, they have incorporated the form 1 and 2.
Hmm.
In form 1 and 2, they have said that they inquired and I have asked for some time.
Hmm.
But it is their contention, it is not my
So that
contention, my lord.
whether their contention
lord,
is
that they
correct
do-
or not.
That the issue, my lord, that
So
inquiry
that
officer.
issue will be decided by whom?
No, that issue would be decided, my lord, before
will decide?
this inquiry officer, my lord, this inquiry officer never did ask me any kind of documents.
Let us be a little
My lord.
rational.
My- No, my lord, that,
Not do that.
to that extent, a read petition, my lord, I am not praying, my lord, but my lord, my lord. Judgment. Para 16 of the judgment, my lord. My lord. May I read, my lord? The learned counsel submitted that the proceeding against the appellant was initiated on the basis of an inquiry conducted in the year 2004. And due to the appellant failing to produce any document before the inquiry officer, the case was referred to the tribunal, and after service of notice, the appellant had appeared on so and prayed for time to file a written statement, which was allowed, and the matter was fixed for so. Yes, in this case, my lord, the proceeding concerned appeared, my lord, before the tribunal. Then all these things, my lord, when the matter went to the Supreme Court, my lord, then all these things, para 34, 35 and all has been made.
Now, this application of this Rahim case,
My lord.
even if it has to be done at the first stage, that has to be, it has to be considered is at the tribunal level, where you will take a stand that they did not hold an inquiry and therefore, for Rahim Ali, this notice cannot come.
My lord.
It is then they will have to
The
decide whether there
tribunal
was an
cannot
inquiry or
take
not.
cognizance also.
If
My
we now interfere at this stage,
My
then
lord.
we are accepting your argument that there was no inquiry and therefore Rahim Ali will squarely apply.
No, my lord, I am at prima facie, I am not praying that my lordship should allow my petition, my lord. Prima facie, my respectful submission before my lordships is that my lord can issue notice, can call
That is
for
what
the
we are
record,
saying.
my lord.
Once
That
the,
whether, my lord,
once the notice is issued and they appear,
my lord.
they will take a stand. We held an inquiry. He did not
No,
produce the
what
document.
will be, my lord,
Hey,
my lord, I'm sorry, my lord.
once the notice is issued and the matter reaches the final stage,
My-
we are talking at the final stage. Respondents take a stand. We did an inquiry. He did not produce it despite it being given a opportunity of producing the documents.
My-
You take a stand. You never asked me. Question of fact, we cannot decide here. Who will decide?
No, my lord, what will be their stand, my lord? Today it will be difficult for my lordships and for
You are
me.
saying that the
No, no.
Form 1 and 2, they
Form
will
1
not
and
go,
2 is there.
they will not go beyond Form 1
But
and
my
2.
lord, once the record comes, my lord, that will be
They
the
cannot
issue.
go beyond Form 1 and 2.
My lord. My lord.
After that, again, the bill will come. Will be Monday.
My lord. Well, my lord can dispose of. My lord. No, he will never say like that, my lord.
Because
Yes, my lord. I have. Paragraph, my lord, the issue is after the order of the tribunal, my lord, that is admitted. Paragraph 3 is also there. Then Supreme Court. But my lord, the
there is
law,
post
but
of form, which we
that-
cannot do.
that is correct, my lord. That
We
is
cannot
not.
do because it will be a disputed question of fact. Whatever is in the form, it's a
My-
disputed fact. You say no, he says yes. That is the form.
But my lord, may kindly imagine, my lord, for a citizens like this natures, my lord, kindly, my lord, for I respectfully beg to submit, my lord, a person has been branded as a foreigner, my lord, has been pushed to the tribunal. I have seen from my very limited experience, my lord, that 99% cases, my lord, all this type of person has been declared to be a foreigner, my lord. Very limited chances, my lord.
A better suggestion perhaps from
My
you
lord.
would go is
My
that
lord.
the persons who are handling the cases, that if you look at all the judgments,
My lord.
this document was not accurately proved, this linkage was not proved.
No, that is
what we go by.
procedural lapses are there.
So, it is not about the authorities who are catching the people. It is about the persons who claim to be able enough to defend them in the manner known in law.
But my lord,
Is what is causing the problem.
that is the issue, my lord, because those persons cannot defend, because along with the notice, the documentary proof or the main grounds.
No,
has
Mr.
never
Bhaiya,
been
you're not,
furnished, my lord.
you're missing the point.
Exhibits that the person who puts up the defense.
That
before the-
will come after the, my lord, notice part, my lord.
That's
That
why
is
we
my
are saying, you
respectful
see,
submission.
you are missing the point. What we are trying to say is that in the tribunals, it is the lawyers who are dealing with the issue.
My lord,
They don't upgrade their skills,
my lord,
correct? And whenever we make an attempt
my lord, my lord.
to interact with the lawyers for upgrading the skills, there's nobody there. 15 days back, I was in the Lawyers Association Guwahati.
My lord.
Mr. You were there. He was the only person, known faces who was there. It was interaction on the in civil law.
My lord.
No lawyer was interested.
Sorry, my lord, I was not.
No, it's not a question. I'm not asking for any explanation for anybody. But the fact is that you see, if lawyers are not there to upgrade the skills,
My lord.
you will have to organize things and have the skill upgradation in district levels where the foreigners cases are taken up.
My lord, my lord.
That's the point we are taking. We are not on the issue A, B, C. We are
Right.
trying to. We are. My brother is a simple man and cannot say it straight.
My lord.
I have I have seasoned, and therefore I can now say that yes, it will be for you to upgrade your skill.
My lord.
If you don't do it,
No, we are always a student.
nobody will be there to take it. In every case, we are finding defects. Most of the cases where remands are made,
My lord.
we find it that this is a fault of the lawyer, not able to do it. This can be taken up.
My lord.
That is why you see, you have read section 106 of the Evidence Act. There are two illustrations. Can you recollect?
My lord, I have to, in evidence act, my lord, I am very poor, my lord. That is another
So
issue.
there, the illustrations, this Evidence Act is a document, is a act, which unless you read the what you call the illustration, you will not understand.
My lord.
There is about the train ticket. So why why not ask a question? Why will the TT come and ask me that you are not with ticket? That is also an accusation. Why in the city bus people will ask you for a ticket? That's not an accusation.
My lord.
Accusation is when they ask you for a ticket, you don't give it.
Don't give it.
Then they are accusing you of a ticketless travel.
My lord.
An inquiry is never in our understanding. An inquiry is not an accusation. An FIR is lodged that in front of near the High Court gate there is a dead body lying.
My lord.
That FIR is not accusing someone for anything.
No, no.
So it is somebody is being suspected. Can he now come to the court and say that, well, police has asked me to come and appear. I am a suspect, therefore please quash it. In the FIR there is no name. No inquiry was made. How did they jump into a conclusion that I am the accused person?
But my lord, the difficulty is that the burden, section 9, on the very first day, my lord, is against the proceeding, my lord. That is the, my lord, difference between the FIR accused and this type of accused, my lord.
Time to give the written statement or the evidence
My-
from whatever little we have seen. It has been given for years. Whereas the time
My lord,
limit is
this,
60 or
in this
90
case,
days.
my lord, after the notice had been issued after 10 years,
Yes.
in
So
this
now,
case.
in the past 10 years,
My
you
lord.
would have some documents, number one. Number
My-
two, suppose you showed some documents to the inquiry officer and said, okay, we are not proceeding against you, we are not referring you. Tomorrow, you stand a chance that another inquiry officer will proceed against you or make a reference. Once you face these proceedings with the proper documents and the proper guidance, get an order in your favor, you are settled for life. When I say you, I mean the petition,
My lord.
the proceeding. He is settled for life.
My lord.
He has a strong case. The documents that you have given appear to be strong, or at least appear to be strong to him.
Presumed to be, but what will
So
be the
now,
fate, my
what
lord,
will
in the trial? It
now
is very
once-
difficult. But just for a, my lord, just a small typographical error, a person has been branded as a foreigner, my lord, just from R to L.
I can cite you examples where the tribunal has recorded counsel for the OP has refused to argue. Counsel for the OP has what was the word? He has agreed to the allegations.
My lord.
That kind of situation people are facing. We sitting here or you standing there, we cannot do much
Well-
about it unless that is educated,
That is correct.
unless it is done properly there. If this kind of notice is interfered with by the High Court, even at this stage,
My lord. It will be a
Mm.
big,
it will not be protecting the persons who may be.
In this petition, you have missed out one thing.
my lord.
You have said everything. Come to page 4. So and so, son of Abdul Subur Ali. Abdul
Sabur.
Subur Ali,
Mal.
alias Abdul Sabir, Abdul Subur, alias,
Oh,
page 4. of your
yes, yes.
petition.
my lord. Alias we have missed out, my lord.
Three aliases you have given.
My lord.
Now come to page 42.
Yes, yes, my lord. That is
One
there.
alias you have missed out.
We have relied on the name of the petitioner from this present
We
records. my lord.
understand, but you see, we have gone that.
Those will be also,
we have seen-
will be come in the trial, my lord.
So this fourth, there is also a fourth, Abdul Sheikh Ali,
My
sorry,
lord, in-
Abdul Sheikh
in-
Ali.
My lord, in this type of cases,
We
from
know.
my very limited experience, my lord, what I have seen,
We don't
in
know.
2-3 documents, there is a variation of names, my lord.
We don't know, but once you say that,
My lord,
Abdul Subur Ali, and you are showing us a document of 1966,
my lord. His
Abdul Sabir,
1966, yes, portal list, my lord.
page 31, yes.
Yes, yes, my lord.
32, Abdul Sabir.
Abdul Sabir, my lord, correct, my lord. This is his, my lord, grandfather, no?
And in the, and he does not have any document other than voter list to connect
My lord.
to his parents.
Because, my lord, at this moment, I do not have, my lord. At this moment, I do not have.
There is no statement here in this writ petition that you are not availing any of the government schemes. You are not having a ration card, you are not having any other schemes, you don't
No,
avail
those,
anything.
my lord, those documents, I have not, my lord.
No document, even the statement is
My
not there.
lord. Then my lord can
The-
dispose of my petition.
I don't want to go into.
My lord.
In past orders.
My lord,
there's not-
my lord.
If you can dictate the order in the chambers, we have too many prayers for upgrading.
Yes, yes, my
If you
lord.
can take it up, we can dictate the order today, you'll have it,
My
or
lord.
otherwise we'll give a date for release of the order.
No, my lord, can, as per convenience of my lord, I do not have any urgency, my lord.
No,
For
it's okay.
convenience of my lordships, my lord.
But we'll make it clear that disposal of this will not affect your rights.
My lord.
And if you are aggrieved, the interlocutory orders can also be assailed by receiving
Fine.
final order.
Highly obliged, highly obliged.
Item 10.
May it pleases your lordship. Lordship impugn order is at page 31. At this stage, I'll pray for issuance of a notice and TCN may be called, lordship.
No protection from deportation.
You
That
don't-
I leave up to the
you don't
lordships.
want us to question you on the issue of maintainability.
Lordship, I leave, I'm appearing as a legal aid counsel, lordship.
Legal aid counsel.
Yes, lordship. And once the TCR is here, lordship, I can argue on merit. Otherwise, she has documents. And
And what is the explanation?
he was
for that
rightly
delay?
said, why I was listening to what lordship was saying. It was not properly placed before the learned tribunal earlier.
We know it.
Because she has very good documents. If she would have been asked for more documents, she would have provided, because all along in the same village, lordship, her parents are there from 66 onwards. Her mother and brother is there. So brother would have advised for adducing evidence before this is the reason one of the prayer in my writ petition is for remanding back the matter before the learned tribunal, lordship. So at this stage, since there are lots of upgradation matters also.
That's really not believable. The reason is
Yes,
you have given us a family tree. You have 6 siblings. You
yes,
have a
sir.
husband.
Yes, sir. Husband is died late.
Oh, okay. We missed out that late. Okay, but you have 3 children.
Yes,
In a house, nobody can be that naive. 6 siblings would mean again a big family.
yes, not true.
So it's not believable that a family with 30, 40 members, nobody is interested to help you in your defense.
Advice also has to be there, lordship.
There's
I don't know whether she was advised to call for her brother or for adducing evidence before the learned tribunal. Because brother and mother together voter list are also there, lordship. Page 78, page 80.
Okay.
And Gaambura certificate was duly proved. Gaambura of father's village. Page 70 is his evidence, lordship. And Gaambura's certificate is at page 95, lordship.
Any reason given for the delayed approach?
Delay that I have stated in paragraph, lordship. Paragraph 30. Delay. Yes, paragraph 26, lordship. Page 23. Legal aid counsel, lordship. Yes, sir. Deep. Yes, Lordship, I didn't get.
Is there any voter list of you and your projected father?
No, Lordship. Her vote, 66 is of grandfather, grandmother, father and mother. 71, grandfather, grandmother, father, mother, and
So it is only that the village headman's
Yes, Lordship. Yes.
identification that is linking you with your parents.
yes, Lordship.
The-
And the
the-
panchayat certificate, that was not proved.
The Kabinama is also not there.
Not there. And panchayat certificate is there, Lordship, but it was not proved. Deep.
Because in this case, the opinion is very, in the opinion, which is at page 31, the evidence is in this, it starts from page 5 and 6. In small font and it's so clumsily written that we couldn't follow the evidence. Page 5, 35 of the opinion. Exhibit 1, 2, 3, 4 is going on writing like that. We couldn't understand anything by plain reading of this. That's why we asked.
Deep.
Item 11.
Had it been made a subparagraph, it would be easier for us to follow.
Lordship.
Exhibit 1, Exhibit 2, Exhibit 3.
Yes, yes, Lordship.
Be easier for us to follow. Otherwise,
Yes.
this is very difficult.
May I please, Your Lordship? But this is
Yes.
ex parte order, Lordship. Order at page 12.
Why ex parte?
Lordship, he submit his WS. Thereafter, he could not appear because he was a serious diabetic patient.
You are Mr. Ali,
Yeah.
but Mr. A. Ali, the counsel appearing for the petitioner. Also heard the counsel appearing for the respondents. The opinion rendered by the Foreigners Tribunal 6th Nagaon, Assam on 26/6/2023 in FT case number, you'll find it page 12. Declaring the petitioner to be a foreigner of the post 1971 period has been assailed in this writ petition. Keeping the issue of maintainability open. Issue notice returnable in 4 weeks. Since the respondents have entered appearance, are represented. Formal notices are dispensed with, however, extra copies within a period of 3 working days from today. Call for the TCR. Prayer for bill will be considered on receipt of the TCR. However, in the meantime, if the petition is apprehended, she should not be deported without further orders of the court.
Did we hear you right? You said that you are a diabetic
Yes, Lordship.
for which you could not take steps.
Yes, Lordship.
can you show us from the medical documents that you are a diabetic?
Yes, Lordship, I have annexed all of.
Yes, yes, we have seen that. We are spending time in reading medical documents. It shows that you are a diabetic from the medical documents. Show us from any document
Lordship, a
in the medical
diabetic
prescriptions or the diagnosis or the pathological test reports that you are a diabetic.
Lordship, a diabetic guidebook has been issued in the name of the petitioner.
I understand. Come to page 26. You must understand that when you are
It's
picking up a medical document,
Lordship.
at least I have an interest. I would see, I have read your, you have given us a ECG. I have also read that ECG.
Yes, Lordship.
Now you have come to page 26.
Lordship.
Random glucose is 271. Correct?
Lordship.
Upper range is 140. Then come to next. Page 27, result is HbA1c is 11%.
Yes, Lordship.
It is risk for long-term complication. It's not a risk now. Now please come to page 29. Result is blood HB is 11.2,
Yes, Lordship.
and in the right-hand column, adult female, normal range is 11.0 to 13.0. That means negative. You don't have a diabetic. Next page is page 30, 11.1. HbAC1 is showing 11.1, which is a risk category. Now please come to again page 32. HB is again 11.4 gram. 11 to 11, 13.0 is the range. Okay, we have issued an order. We don't say anything at this moment.
Item 12.
Compliance.
And page 23.
Lordship.
You have seen that?
The top line.
First line. Read it, read that.
Compliance sport.
Compliance poor. She
Poor.
does not comply with the advice.
That means
of the doctor.
whenever you go to a doctor, you don't take medicine and go and your HB is high.
Nice. Compliance.
Correct? So next time when you produce a medical document, be very careful.
Lordship.
We'll take a short break and come back.
Notice.
Yeah, we'll do it. Yes.
My lord, this may be taken up with in the supplementary 48 and 49. Day before yesterday, matter was listed, my lord, Torapali.
This is 2017.
My lord. So there is this impugned order was challenged earlier, my lord. And the order, my lord, is page number 38, my lord. His brother case is listed at supplementary 48, 49.
48, 49. Okay. Give that one.
The nephew has challenged the order, my lord, because they are in detention. And earlier, a case was filed to stop the pushback, my lord. That is pending before your lordship.
Okay, we'll take
My
a
lord.
break and come back.
My lord, my lord.
Monday. Next. Huh?
ছাৰৰ ঘৰত থাকিব কথা পাতিম।
Upgraded item 32.
My lord, where is your written statement?
He could not, my lord, participate in the quiz, my lord. He appeared, but no written statement, no evidence has been submitted due to COVID-19, my lord, and he suffers serious illness, my lord. Till date, my lord, he is suffering illness, my lord, serious illness. My lord.
Bhoppi has filed a written statement.
Statement has been filed.
Page 64.
Statement filed, evidence.
But where is the written statement?
Statement 53, page 53. was from my lord village Barjari Mazga under Jamuna PS, my lord. He born in the year of 1962. 63.
You were given sufficient opportunity, you did not produce it anything. Don't think you have a good case.
Let me see there, originated from the village Barjari
You
Mazga under
were
Jamuna PS.
unrepresented on one.
His father's name was there
Yeah.
in the voter list in 66.
No, but that we can't look into. Once you don't give evidence. You have given more than sufficient time.
My lord, he was, my lord, means he has health problem at that time, my lord, he could not communicate his counsel, my lord.
No, but there's no material here that to show that the petitioner was ill.
During the COVID-19, he could not, move there, my lord.
No, okay, even if
His
we conclude
English
that,
counsel also, my lord,
even if we conclude
went
that,
to,
no, because there's no explanation. 11 dates you are not represented.
yes, my lord.
11,
It is,
no, 12, 13.
uh,
13 date, you are not represented.
we are expected that his counsel may appear, but his counsel also failed to appear, my lord.
We also need those counsel
My lord,
who will appear
Kindly-
without instruction.
kindly, my lord, consider the matter. He is ill person, my lord. Matter may be remand, my lord. I will
If you can search for one,
produce
we'll make
evidence,
that-
my lord, there.
No, no, if you can search for one and give us the name, we'll make he or her very famous.
I will produce evidence, my lord, another evidence there, my lord.
No, but the
To
default
produce
is,
my-
default is more than what we can expect. 13 dates.
Yes,
the
my lord.
petitioner is not
It is
presented.
there, my lord.
And there's
The
no
fact that
explanation.
He could not appear, my lord. Due to his negligence or maybe the negligence of his counsel, my lord.
No, not counsel.
Not from. One chance may, he is the genuine person, my lord, he is genuine Indian citizen, my lord. His father, my lord. His, and other family member of the petitioner. Give a chance, my lord.
The petitioner would not be
Beg
entitled.
your pardon, my lord. My lord, he is a poor person and his family, my lord. His other family member is there without any objection, my lord, enjoying their life, my lord. And due to his negligence or, my lord,
No, we don't know. We can't comment. There's no material on record to show that.
we kindly see his that document, his father's document, his father's passport is there, my lord, I annex. Page 42, my
No,
lord.
but then what is the justification not to produce it? You say that you have pata which was issued to you long back in 67. But every time you took adjournments, you said that there were no documents. You wanted some time to procure documents. The documents annexed here, the documents which are annexed here, come to page 37. This is obtained in the year 2014. There was no reason not to produce this. Page 39, again procured in 2014. Out the documents. Please come to page 45.
45 years.
Yes. Page 45 is of what date? Eleven six 65. Page 45.
45, my lord. 11/6.
11/6/65. That
65, it's page 65.
yes, because that you will find in your written statement.
Yes, my lord.
In your written statement, you have made a statement that it is 65.
65, yes.
Correct.
Yes.
Now come to page 16.
16.
Yes.
My lord. 16 is the affidavit. Sixteen is the affidavit of the petitioner, my lord. And forty-five is the passport of the father, my lord.
The question which is coming from the court is,
My lord,
you were born in 1963 or 64
my lord,
for your age,
My lord.
also in your written statement.
my lord.
This passport is issued in the year 1965,
Yes, my lord,
11/6/1965, as per your written statement also.
my lord.
Now, this passport only says your father has one child. If you were born in 63 or 65, when
Yes,
this passport was made,
my
the
lord,
number of children would be at least two because you have an elder brother.
my lord. My lord, yes.
This passport does not record
Yes.
your existence in the
Yes.
year 1965.
Yes, my lord.
Therefore, the
There is, now, yeah, some mistake
No,
may
we
be
don't
there,
know.
my lord.
We
Some
don't know.
mistake may be there because of no record of his birth, my lord, is there, my lord.
No, but this is certain. This was made in 65
Yes,
and you are 61. You must be making that statement because of some reason.
my lord. There is no birth certificate, my lord. That's why 1 year or 2 year maybe here and there, my lord.
But the father does not disclose you in the passport.
Yes, my lord. At that time may not be there, my lord. Maybe thereafter he may born, my lord. No, no. It doesn't- it doesn't work. So, No, no.
Father, any
Ye-
voter
ye-
wish to
ye-
connect
ye-
you with
Yes,
the father?
yes, yes, my lord. One voter folio is there, my lord.
Hmm?
Voter folio, my lord. Can you see page 19? Page 19, particular, my lord, and type copy is 417, my lord. In the year of 1985, he enrolled along with his father, my lord. Twenty-three, 85 over 23, what do you say? 62. May I submit few document, no, with the affidavit, with the additional affidavit, madam? My lord, my lord, I'm willing person, my lord, only not to arrest me, my lord.
One is the delay in the proceedings.
Yes, my lord.
The second is the documents which you have shown. Third is the explanation from the date of the opinion till you have filed this writ petition in 2025.
Yes,
Three
It is
reasons to
one.
be dissatisfied for the purpose of bail.
kindly, this,
No, no. You have to be satisfied.
allow him to, my lord, examine himself,
No,
medical. exam.
we are giving you that
My lord,
liberty
my lord,
because
he
we are
is
not,
the ailing person, my lord.
we understand, but
Last time he came here, my lord, with
then
the stick and
on merit we don't find anything unless you satisfy us.
unless your lordship grant bail, my lord, he could
No,
not.
no. We are not granting bail. He has the protection of not being deported. Both sides are represented
No, till next date, my lord,
on the
till next.
period made by Mr. A.J. Atiyar and counsel for the petitioner. The matter stands adjourned today as the the matter stands adjourned today. List on, give a date after the opening, give a fixed date.
In the month of November, my lord, because
You'll not be there. Okay. Choose a date. Is a calendar in front of you. Okay, choose any Monday, Monday, Wednesday, or Friday.
November, 18 November, my lord.
18 now.
Some,
We are unable to because we have seen the documents.
I request you, man.
I've,
My lord,
we have
kindly,
we have
kindly.
examined the documents. We are not three reasons.
Well, I will satisfy you, my lord, in the next date, my lord. With reducing some additional documents, my lord.
No, yes.
My lord, please, my lord.
No, no, no. We
My
are
lord,
unable to.
Only for some time, for the.
No, you see,
for
in
the-
order to give that benefit, we were looking at each and every document. We have taken some time.
Yes, my lord,
It's
I agree, my lord.
just not a
There is
perfectly,
negligence, there is some.
just not a perfectly adjournment. We examined
My
the
lord.
records. We did not want to dismiss it today.
My lord,
Today we were not
Obliged, my
inclined to
lord.
dismiss it.
That-
Just
obliged, my lord, very much obliged, my lord. Kindly, one
No, no.
chance to,
we have certain parameters and it doesn't match that. But we are not dismissing it today just because
yes,
Mr.
yes, my
Arya is
lord,
there.
very much obliged, my lord.
See, yes, item 31.
31, Lordship, I could not able to grant full lordship.
Huh?
I could not able to grant full lordship if
You see, we'll tell you what has happened here.
Yes.
At the down below, you will find the admission register exhibit 1, 1, 1, 2, 1, 3. Folded document at the end, after the evidence of the DW, you will find,
Yes, okay.
correct?
Mm.
First page is exhibit 1/2, 1/1. Next page is 1/2,
Yes,
correct? First name is the name of the petitioner,
yes,
correct? Now, the admission register was produced. The requirement under law is the admission register. But now the tribunal says that attendance register was not brought.
yes.
Now, if you, perhaps if attendance register is required, we also may be disqualified. I don't know whether my school would be maintaining attendance register,
Okay.
but what about the entry here? If this entry, you see, come to the opinion, in opinion, the marking is wrong. It says one numerical 1, 2, and 3. In the opinion at page 70.
72. 11.
72 is 1/1, 1/2. But in the marking, it is 1 by Roman 1. Correct?
Yes.
Now, they discussed about this. As per the register, admission register, the date of birth is so and so. In examination open 3, so and so, portfolio, OP left the school in so and so. Correct.
Yes,
Now,
sir.
last line is OP3 has not brought the student's attendance register. Now,
Yes.
attendance register, was it called? No school will be maintaining it. It's not a compulsory document to be maintained. Monthly register, who will maintain? Which school will maintain? And that is why this evidence was rejected. And you know, just before that attendance register, you've seen that school register?
Yes, yes, sir.
Just one page before that.
In opinion.
No.
Oh, yes.
Trial court records.
The evidence of the.
Last page, school register.
Yes.
One page before that. No, one page before that.
This is evidence of the headmaster.
Before that.
Not, sir.
You got it? Just send it to us. One or two pages here and there, you will find an election commission document. The election officer's document. Yes, that one. Yes. The pre-page is there.
Extra copy of notice of 1970.
Yes, pre-page to that. Yes, this is certificate.
Yes, sir.
Correct. Now the election officer, it is authenticate.
Hmm.
First name in the second page.
Hmm.
No, after that page. Next one. First name is the name of the father of the petitioner. Correct. What happens to that? An inquiry made by the tribunal. Why will the tribunal not deal with it now? It's good, Mr. Sharma.
Yes, Doctor.
We appreciate what you are doing.
Yes.
We appreciate that. In fact, please go through it. You are doing the right thing.
Yes, Doctor. Regarding that, no order was passed, Lordship.
We were following you. Just send it back.
Yes.
There's one document we missed it out when we were looking at it. No, nine. No,
Lordship.
There is the evidence of PW, DW, OPW 1, 2, 3.
Yeah.
After a few pages only. There are exhibited documents also. Yes, these are exhibited just before that. Just before these documents start. Yes. Now you see, this DW1
Yeah.
does not prove any document. This is DW4.
Yes, this is the.
DW4 exhibits the documents.
Yes.
Correct. Now, after that, after then, these documents are there.
Yes.
The documents, exhibit 1 is signed.
Yes.
School certificate, that is signed.
Yes. No.
Exhibit 2, 3, 4 onwards is not signed.
Yes.
Correct?
Yes.
Now, in the evidence of DW4, you will find exhibit 1, 2, 3, 4 referred.
Mhm. Yes. No.
Correct?
Yes.
Next page, please turn over the page. No signature of the presiding officer. Correct?
Yes. No.
Now, DW1 is after that. DW1, 2, 3, they are after this. Yes. Yes, this. Handwritten. It is deposition before the court,
Yes. No.
not an affidavit.
Yes.
Correct?
Yes.
So the documents are there, and this the DW1 and OPW1, OPW2 does not prove any document.
Yes. No.
Then comes this OPW3, exhibits 1 again.
Yes. No.
Correct?
Full practical.
Now, in the opinion, the presiding officer writes that 60 and 70 are proved.
Yes.
Look at this evidence. Sorry, this opinion. Page 74, Roman 3. Except voter list 66 and 70, no other voter list can be proved.
Yes. No.
Now, even exhibit that 1 and 2 is not exhibited.
Yes. No.
3, 4, we have shown you in the evidence. Other voters lists are there in the evidence of DW4.
Yes.
Therefore, the tribunal is missing out the evidence.
Yes.
It has to go back. And for that document, we were missing a sequence. Election branch
Yes.
document. We were missing a sequence. Now we have found it.
Yes. No.
In this came to the tribunal between this is 22. Correct?
Lordship.
2020 or something. We forgot the date.
24 to 2.
Yes. So in between, you see the order sheet, you will
Yes.
find it a gap between 20 and this date.
Yes. No.
There's a gap. So it came in the off date.
Yes. No.
And after that, the tribunal was closed because of COVID.
Yes.
And this document, which was called for, was never brought to the notice of the presiding officer.
Yes.
And otherwise also, he said that these documents are proved.
Yes, Lord.
And exhibit 1, we find that there is a link. We are remanding this matter back. And Mr. A.G. Atia, learned counsel for the petitioner. Also heard so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated 26/10/2023, page 70, passed by so and so and so and so, thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. We put on record that the learned standing counsel for the FT matters has opposed the challenge to the said impugned opinion. Next para. It is on a perusal of the records of the tribunal, that had been called for, the court notices that the petitioner had examined herself as OPW1 one Azimuddin, AZIMUDDIN, one word. Who had affixed his signature in the deposition sheet as Mohammed MD, Azim, AZIM, next word, Uddin. Was examined as OPW2. Next for the one Gopal Chetri, Sri Gopal Chetri, CHETRY, the assistant headmaster of Sildubi, SILDUBI, high school, was examined as OPW3, and he had exhibited the school certificate of the petitioner. No. He had exhibited the cover page of the school admission register as exhibit 1 within bracket numerical 1, the relevant page of the school register containing the name of the petitioner within bracket proved in original as exhibit 1 within bracket 2, and the counterfolio of this certificate issued by the school was exhibited as exhibit 1 within bracket 3, and his signature in the said certificate was marked as exhibit 1/4, within bracket 4. Full stop. The petitioner has also examined one Mustafa Ali, MUSTAFA Ali, as DW4, who claims that the petitioner was petitioner is her elder sister, and he has exhibited the the voters list of copy of voters list of 1966 within bracket exhibit 3, voters list of 1970 within bracket exhibit 4, voters list of copy of voters list of 1997 within bracket exhibit 5, copy of voters list of 2010 as exhibit 6, copy of voters list of 2014 as exhibit 7, full stop. It is also noticed that pursuant to just at the end, you will find one petition 3492 or something. Yes, somewhere here of 2020. 32 something, 34 or something. Just pass it on. At the end, where your hand is, in fact, it should be there only. Huh? It is also seen that by a petition dated 3239 of 19, public 19, dated 24/9/2019, on the learned tribunal had passed an order allowing the petition to summon the election officer from a Hojai. We also take notice that in the records of the tribunal, there's a letter bearing number HJEL full stop 19/2019/264 dated 20 February 2020, issued by the in charge election officer Hojai, Shankardev Nagar, verifying the authenticity of the voters list, public electoral roll of 1966 and 1970, and has stated that on verification, the same are found to be genuine. Full stop. As per the endorsement made in the body of the said letter, from it appears that the Foreigners Tribunal had received the said communication on 24/2/2020 at 12:30 PM. So, however, that was not the date fixed for the proceedings. And therefore, the matter was not put up before the learned member. Full stop. However, from 33/2020 to 8/7/2020, the matter was thereafter listed. You strike it out. The matter was thereafter listed on 33/2020, 28/5/2020, and 8/7/2020. But as lockdown was there due to COVID-19 pandemic, nobody was represented. No, nobody was represented. Full stop. It appears that the petition of the tribunal was never brought to the office, letter of the election officer dated 22/2020, which is available at page 69 to 72 of the trial court record, tribunal's record. The letter and enclosures. Next paragraph. However, it is noticed that in the learned tribunal, in the impugned opinion, though did not discard the documents which were marked as Exhibit 1 within bracket 1, TO2, 1 within bracket 4, but the school certificate within bracket Exhibit 1 was discarded only because the OPW3 did not bring the students' attendance register where the name of the petitioner appeared. Full stop. Moreover, in paragraph 13 within bracket small Roman 3, the learned tribunal had recorded that except for voters list of 1966 and 1970, no other voters list has been proved. In this regard, on examination of the tribunal's records, it is seen that except for Exhibit 1, Q2 1/4, the tribunal has not affixed its authentication signature to any of the exhibited documents, including Exhibit 3 and 4, which are the certified copies of voters list of 1966 and 1970. Next one. Therefore, court is of the considered opinion that the learned tribunal did not consider the evidence which is available on record and the finding that no other voters list was exhibited is found to be contrary to the contents of of paragraph 11 of the opinion, where the learned tribunal has mentioned that OPW4 has exhibited Exhibit 3 to Exhibit 6, which are voters list of 66, 1970, 1997, 2005, and 2010 and 2014. Exhibit 2 and 3, that will be 3 and 4. Therefore, in light of the contents of paragraph 13, no, sorry, 11 and 13 within bracket 3, the finding at paragraph 13 within bracket 3 of the impugn opinion appears to be perverse, rendered without appreciating the evidence which is available on record, and also referred to in paragraph 11 of the said opinion. Full stop. As the petitioner had taken steps to summon the election officer, it was the duty, when the tribunal received the communication from the election office, it was the duty of the tribunal to make it known to the learned counsel for the petitioner under such circumstances, having found that the impugn opinion is vitiated for non-consideration of the evidence on record, and taking into consideration the non-availability of admission register, which was never called for. The learned tribunal has not referred to any substantive provision or provisions of law or rules made thereunder, applicable for the high schools in the state of Assam to maintain record of the attendance register of all students, the court is of the considered opinion that this is an issue which has to be relooked into by the learned tribunal. Next, resultantly, in view of the discussions above, court is of the considered opinion that the impugn opinion dated 26/10/2023, passed by page 70, cannot be sustained on facts and in law, owing to non-consideration of the evidence on record. Next, resultantly, the matter is remanded back to the said learned tribunal for a fresh decision after due appreciation of the evidence on record, and to give an opportunity to the petitioner to take note of the to take such steps as the petitioner will so advise in respect of the document produced by the election office, as referred to above. Next. The petitioner is directed to appear before the learned member, foreigners tribunal, so and so. On or before 24/10/2025, without any requirement for the tribunal to issue any fresh notice. Accordingly, the learned counsel for the petitioner is shall communicate this order to the petitioner. Next paragraph. It is made clear that if the petitioner does not appear on the before the learned tribunal on the date fixed, it would be open to the said learned tribunal to treat the petitioner as absent on call and pass such appropriate orders as it may so deem fit and proper. Which school will put it? High school. Any law for maintaining the records of attendance register of high school? I said it will be ME school. Still to be ME school. Next, the registry shall send back the records back to the learned tribunal expeditiously. All right.
Upgraded item 33.
My That's High order dated my letter 27/8/2025 my lord. The petitioner was directed to my lord, produce the original land documents, my lord, which was
Yes.
executed, my lord. My lord, I have collected, my lord.
Okay. Then we'll have to give him bail. Mr. Sharma,
Lordship.
this is a document of 1955.
Okay.
Just see this, so then the finding would not be correct. This has the seal in the top. It is vague, sorry, not very clear. Impression is not very clear. No, not, no, next page. Yes, in the top. Down seal is there in between.
Yes.
Seal is there.
Yes, bro.
And even the first page, last side, down below, first page, no, second page, sorry, down below, before the signature is also in seal, rubber stamp.
Yes, bro.
No, not the first page, second page.
Yes, bro.
Yes, very hand, yes. It has the,
Yes.
heard Mohammed A. Hussein,
Yes, my lord.
learned counsel for the petitioner, also heard so and so for the respondents. Next para, pursuant to order dated 27/8/2025, the learned counsel for the petitioner has produced the laminated copy of exhibit C within packet annexure 4 to the rate petition. Project that the predecessor of the petitioner had annual Kiras Patta land issued on 12/11/1955. Next. Pata. Without commenting on the said document, the court is of the considered opinion that the prayer made by the learned counsel for the petitioner for granting bail to the petitioner be considered. Full stop. Next para, the learned counsel for the FT matters has opposed the prayer for bail for the petitioner on the ground that there is a delay in approaching the court. Next para, either as it may, in view of the projection made in this writ petition, the court is inclined to grant bail 10 days time to take bail of rupees 5,000 to the satisfaction of
My lord,
SP order
Udalguri, my lord. SPB,
Udalguri.
Udalguri.
As the records is received, the court is inclined to issue rule returnable forthwith without requiring the petitioner to take any further steps. This is the matter for hearing in the month of November 2025.
God bless me.
Upgraded item 36.
Lordship may kindly peruse the order dated 29/7/25. We have made necessary correction post title. Lord. 29/7/25. Lordship number 6. Lord. You may be allowed to take steps upon. J.H. Lusker. J.H. Lusker. J for Jamal. J for J.H. Lusker.
For 1 to 5. Lord.
29/7/2025, the correct postal address of the respondent number 6 has been brought on record. Accordingly, issue notice on respondent number 6 which is made returnable on, give a date after 1 month. Returnable on so and so. The petitioner shall take steps within 2 days for service of notice on respond number 6 by registered post with AD.
Let me. Here now.
Next, the Learned Counsel for the petitioner is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next, list on
22nd October.
All right.
37.
I upgraded item 37.
What is there?
Your Lordship, Mr. KL is on legs. Kindly pass on the matter.
Upgraded item 38.
Yeah, please, Lordship. After the petitioner filed a writ petition challenging the order of the FT court, Lordship, on dated 31/8/2021, Lordship, passed by the FT court, FT third Morigao, but the Honorable Court dismissed the writ petition in the motion stage, Lordship, on opinion that, Lordship, documents exhibited did not establish any link with the father, Lordship. And another, there is delay of 4 years for filing the writ petition, Lordship. Lordship, regarding documents, linked documents, Lordship, the petitioner has submitted some new documents along with the writ petition, whatever exhibited in the writ petition. Besides, some documents have been annexed in this revision petition, which will prove the good link between the petitioner and his father, Lordship. And Lordship, regarding the delay,
Take
Lordship,
into consideration any document which was not there before the tribunal.
Lordship. Lordship, this time we have annexed, Lordship.
No, you may annex 100 documents, but the question is not that. We are asking you a question
Yes.
that whether it's statutory jurisdiction, the court has the jurisdiction to look into documents which are not exhibited before the tribunal.
Lordship, Honorable Court may consider, Lordship, because at that time this document was not exhibited in the trial court, FT, Lordship.
May consider means discretion of the court.
Discretion.
May consider will include in the General Clauses Act power not to consider also. Power to consider will include power not to consider also.
Yes, Lordship.
Then
Lordship, but it is the, Lordship, fundamental rights of the petitioner, Lordship, regarding the citizenship, Lordship. And in his judgment,
please overcome paragraph 12 of the order.
Lordship.
Please overcome paragraph 12 of the order.
Paragraph?
Paragraph 12 of the order, which is detailed in this review petition.
Lordship, regarding, Lordship, projected Regarding projected further lawsuit. Okay, the FP code.
Page 19. Page 12.
Projected further lawsuit. Both are- Lordship. Yes, Lord. Yes, Lordship, there is a discrimination. Lordship. Yes, Lordship. Lordship, that made some clerical mistake. Yes. Yes, Lordship. Yes, Lord. Yes, Lord. Some discrepancy is there, Lordship. That I admit, but Lordship, it may some clerical mistake also, Lordship. Lordship, I have not gone through the repetition today, Lordship. Lord. My submission was Lordship. Lordship, my submission was if the review petition will be allowed, Lordship. We come, Lordship, along with the other, Lordship, today I am saying that I have actually appeared for review, granting of review, Lordship. Then Lordship, fix it. Lordship, there are some judgment, Lordship, actually, there. Lordship. Yes, Lordship. Lordship, kindly, MM Rahman, Lordship. Kindly lordship fix in another date, lordship, for my preparation, lordship. And I have got a judgment, lordship also. Lordship, one case law, I have to the law. Paragraph 63.
Two case, only two case I am written.
That the case has been finished on 31/8/2021. And it is further stated that due to poverty, the petitioner could not go to an advocate for proper legal assistance. And a poor person always avoids advocates to save money. Full stop. The said statement, in the opinion of the court, does not deserve any consideration in view of the fact that each and every district of the state of Assam does have district legal services authority where free services are provided and duly advertised and clearly projected in all the district courts. Therefore, as the petitioner is found to have presumed that the case is finished and did not go to a lawyer to take advice, or there is no explanation why the petitioner could not even speak to his own counsel who was holding the brief for him before the Foreigners Tribunal and understand what in what manner the case is disposed of. Is an admission on part of the petitioner that the petitioner remained nonchalant and unconcerned with the nature of opinion rendered when the issue before the Foreigners Tribunal was the citizenship of the petitioner. Full stop. Accordingly, ground number 3 also does not merit any consideration. Next one. In view of the admission that the petitioner did not go to seek legal assistance, also demolishes the ground number 4 of the review petition, that procedural technicalities must yield to substantive justice when the petitioner is though knowing that an opinion has been rendered on 31/8/2021, did not take appropriate steps to safeguard her own citizenship or other civil liberties involved. Full stop. The entertaining of the writ petitions at a belated stage cannot be given an imprimatur of the court, as if there's no duty on part of the litigant to explain why the delay had occurred in approaching the court to assert his fundamental and legal rights. Next para. Despite the court refusing to examine documents which were not before the tribunal, as held in the order dated 28/5/2025, once again, the petitioner has annexed further documents to support ground number 5. Full stop. It is not the case of the petitioner in ground number 5 that despite due diligence, the documents which are now annexed as Annexure 2 to 8 were not within his knowledge and could not be produced for causes shown. Were produced before the tribunal for causes shown. Full stop. Therefore, since the limitations of the writ court while exercising certiorari jurisdiction is well laid down in the case of Bikardhan Das within the Supra. The examination of further documents, which is annexed to this review petition, would be hit by the same principles of law. Next para. Resultantly, it- it- Next, the learned counsel, in the review petition, the petitioner has referred to the case of Lily Thomas within bracket Supra regarding the grounds under which review is permissible. Full stop. As stated herein before, neither the petitioner has been able to disclose manifest error in the order of the court, nor any reasons have been assigned regarding new documents which are annexed to this writ petition. And therefore, the principles laid down in the case of Lily Thomas would not help the petitioner in any manner. So with Supra, within the petitioner in any manner. Next paragraph. By referring to the case of Kamlesh Verma, who had been Supra, the principle laid down in the said case is that the non-consideration of materials on record is a ground for review. As stated herein before, no attempt has been made by the learned counsel for the petitioner to disclose which material on record the court had not considered. Full stop. In this regard, we may again clarify that material on record in the cases against, in the cases where the opinion of the tribunals are challenged would only be referable to the records of the tribunal and not any other documents which are annexed to the writ petition, as those cannot be considered in exercise of statutory jurisdiction. And therefore, case of English Burma within brackets does not help the petitioner in any way. Next para. The learned counsel for the petitioners also referred to the case of Khudiram Chakma, then with Supra. Stop. In the case of Khudiram Chakma within bracket Supra, the facts are wholly dissimilar. Full stop. The said judgment refers to the history of creation of the state of Arunachal Pradesh, which was earlier a province under the state of Assam, and was then referred to as Northeast Frontier Agency. Full stop. It may be briefly mentioned that originally the historical fact is that about 56 families of Chakmas, Chakmas, of the erstwhile East Pakistan were given refugee status and were given shelter in the government camp at Lido in the district of Dibrugarh. And later on in 1966, they were shifted to a camp at Miao, MIAO, within the present state of Arunachal Pradesh. And it is in that context that section 6A of the Citizenship Act was being considered conjointly with immigrants within bracket expulsion from Assam bracket close Act, 1950. And it is in this said context that the Supreme Court of India arrived at its well-considered decision that by the northeastern areas within bracket reorganization bracket close Act, 1971, the territories of Arunachal Pradesh were excluded from the purview of the immigrants within bracket expulsion from Assam bracket close Act, 1950. And it is in this said context that the issue relating to the case of Khudiram Chakma within bracket Supra was appreciated by the Supreme Court of India. it would be appropriate to refer to paragraph 75 of the case of Khudiram Chakma within bracket Supra, which is quoted below. Yeah, 75. Therefore, comma, although a reference is made to the law laid down in the case of Kennedy, Kennedy versus Mendoza, Mendoza dash Martinez, Martinez, comma, 372 US 144, comma, 159, wherein the following statement was made, inward commas, citizenship is a most precious right, inward comma closed, comma, yet the issue of citizenship was not gone into, as would be, which could be found from paragraph 75 of the said order as quoted above. The issue was regarding the settlement of the Chakma refugees and had nothing to do with consideration of the issue of citizenship within the meaning of section 6A of the Citizenship Act, 1955. So accordingly, this said case also does not help the petitioner in any manner. Full stop. On the same ground, the case of Gopal Das within bracket Supra and Ranjit Rai within Supra and this cited in the review petition is also not applicable in the case of the petitioner. Next paragraph. Neither in the writ petition nor in this review petition or the learned counsel of the petitioner could demonstrate that the fundamental principles of burden of proof was ignored by this court, or that there was no procedural compliance and the issue of natural justice to the petitioner was not provided for either in the before the foreigners tribunal or before this court. Under such circumstances, comma, the case of Sarvanan Sonwar within bracket Supra, Amina Khatun within bracket Supra, and Maneka Gandhi within Supra, comma, does not come to the aid of the petitioner. Next paragraph. The petitioner has also cited the case of Hindustan Development Corporation within bracket Supra regarding legitimate expectation. Full stop. In what manner the issue of legitimate expectation would help the petitioner is not spelled out in the review petition or nor addressed by the learned counsel for the petitioner. Stop. Accordingly, the said case also does not help the petitioner in any manner. Next paragraph. No other submissions was made before this court. Next paragraph. Accordingly, we don't find any merit in this review petition. The same is dismissed at the Dismiss without issuance of notice on the respondents. Yes.
39, upgraded.
But with your lordship. This is an interlocutory application. Praying for correction of a order. The lordship has passed in that PSC matters, my lord.
What is the error?
Lordship will kindly turn to page 44 of the IA.
Info.
44, my lord, 44.
Yes.
Yes, here, my lord, link case April 335 of 2023 is reflected, Abhishek Borbora. However, in the body of the judgment in para 5, it has been erroneously omitted, my lord.
Para 5.
Para 5 of the judgment, page 67, it starts. Page 67 of the internal page 44.
Page number
67.
67. Can you give us the particulars which we have missed out?
Yes, well, I have given in the
Where is that?
only the name of the petitioner, that
No,
is
it's okay, but what is to be written? There are 6 columns. What is to be written where?
here, my lord, Assam Excise Service, Abhishek Borbora, Inspector of Excise.
Yes.
Yes, I will give it in writing, ma'am.
Just keep this paper and write it down as
Yes,
this
ma'am.
column wise. Just give this to him. Give the paper. We took so much of trouble
Yes, yes.
in
My lord,
making this chart. No, not that.
Yeah.
We made so much of what you call effort to make this chart. Again, error kept in. We regret that.
Somehow, my lord, it was left on our part, my lord.
No, we don't say. We won't say that. But somehow we missed it out. By separate hands, we did this exercise so that if A makes a mistake, we will catch it. Despite everything, this error has crept in. We will incorporate this.
Yes.
Patwari,
Lordship.
we dictate the order, please you give
Lord-
this. Will be Assam Civil Service Junior Grade,
No, it's Assam Excise Service, no.
Assam,
Excise Service.
Excise
I've
Service.
written that, my lord.
Assam Excise Service is at
And page 10, annexure A. Rule, page 10 of this IA, rule 19.2.
oh, it will be a separate entry.
It's separate entry. Though it was reflected, however, in that particular para, it has been omitted. my lord.
Okay. So it will come after the end of page 69
Yes, at the last.
as
my lord.
at serial number 53 will make
Yes,
it.
yes, yes.
Okay. Who's for the government? Mr. Hazarika is normally always there. Mr. Adhikari, just see. But Mr. J. Patwari can count for the petition. also heard Mr. H.K. Hazarika, an government advocate. Oh no, this is excise.
Yes.
Excise will be Mr. P. N.
Argo.
Goswami. Thank you, Mr. Adhikari. Mr. Hazarika, this is the APSC matter, but now I see that this refers to excise department. Excise department is handled by
There are some spending envelope, right?
Mr. P. N. Goswami is there. Can you see someone from the excise
sir,
department
sure.
can,
We'll go back.
because as a government advocate, you don't appear in excise matters.
Yes, Lordship.
You appear.
No, Lordship.
You, no, you don't appear. Okay. And suppose, and because of the excise department, representing all the respondents. Next paragraph. By filing this interlocutory application, the applicant, who's the appellant in WA 335 of 2023, is seeking for modification of the alteration of the correction of the judgment and order dated 26/2025, passed by this court in WA 335 of 2023, which is a common judgment and order rendered in several connected writ petitions, writ appeals. Next para. The learned counsel for the applicant has submitted that the applicant, namely Abhishek Borbora, Sri Abhishek, ABHISHEK Borbora, who is the appellant in WA 335 of 2023, was selected and appointed in the Assam Excise Service as Inspector of Excise, and that his service was governed by the Assam Excise Service Rules, 1990. Mr. Power, his name is found to be inadvertently omitted in the relevant paragraph 5, 54 and 62 of the said common order, common judgment and order dated 26/2025, passed in WA 335 of 2023 and other connected matters. So accordingly, it is submitted that the name of the applicant be also inserted in the said relevant paragraphs. Next paragraph. From the submissions made by the Learned Counsel for the, Mr. Bhattakur, you'll be there? Mr. I. Bhattakur, for the Excise Department. Having, his name is omitted.
Yes,
In
I have
paragraph
checked.
5, in the chart it is omitted. Stop. The inadvertent omission of the name of the applicant in the impugned judgment and order is also admitted by the learned standing counsel to the excise department. Next para, accordingly. Accordingly the name of Abhishek Borbora accordingly, the court is inclined to order as follows. Like number one, that in the chart at the end of paragraph 5 of the said order, a column be inserted with the heading of Assam Excise Service and in the chart and a chart be inserted below the said heading containing the following columns. Give a column and then one within bracket, serial number, number 2, this page, see page 69, 69, this is chart. So same format, chart. Then next row would be serial number 53 with WPC number
4043 of 2020. 4043 of 2023.
4043 of 2023, comma, WA number
3335.
335 of 2023, name of the petitioner, Abhishek Borbora, accused number will be accused number
Yes.
Accused 41.
41, my lord.
41
All one.
and name is and supplementary charge sheet number
Final chart.
Roman 4. Roman supplementary charge sheet, Roman 4.
Roman 4. Okay, Roman 4. At the end of existing paragraph 54 of the said order, comma, a new subparagraph under the heading of Assam Excise Service Rules, comma, 1990 be added with along with quoting along with the rule 19 within bracket 2 be quoted thereunder. So at the end of paragraph 62 of the said order, comma, new subparagraph number 6 be added with the following sentence. As per Rule 19 within bracket 2 of the Assam Excise Service Rules, 1990. Is the paragraph? That's the rule.
The page 10, rule starts at page 10.
Of which book?
IMI.
We were
The
next.
IA.
Rule is quoted.
Yeah, you know,
We were
rule
next.
annex,
We were next.
annex the rule. Page 10 of the I.
You've taken care of everything.
Yes.
It's 20. No, we are referring to the probation period,
Then rule 22, my lord.
22. There it will be 22 then.
21, 22.
No.
20 21 and 22, my lord. 21, sorry, not 20.
21, yes.
21,
it will be
22 is
21.
gradation list, sorry. I apologize.
21, no, it's okay. 21,
Yeah.
Code Rule 21, from page 20 and 21. Huh? Putting up red pencil mark. We make it, we could make it smaller, no? Okay, you say paragraph 6 with the following sentence. As per the provisions of Rule 21 within bracket 1 and proviso thereto of the Assam Excise Service Rules, the probation period is 2 years, subject to extension, not exceeding a period of 2 years. Only that, don't quote. Petition is not required. Next paragraph. Accordingly, this order shall be read together with the order dated 20 June 2025, passed by this court in WA 335 and 2023, along with corrected cases. Next para, the it is clarified that this order only supplements the left out particulars of the petitioner, of the applicant, without touching anything on the merit of the said order. Dated, said judgment and order dated 20 June 2025. Just a query. I'm not following that order, but I'm just wanting to ask, any appeals have been filed?
My lord, initially, my lord, the government, by misinterpreting your lawsuit order, has again discharged us without giving an opportunity. Some writ petitions are pending and few SLPs has been filed, I am
Okay.
told, my lord.
Okay. To the other members of the bar, I am sorry, we can't take up the matters. There's we have an assignment to be taken up. You have this criminal writ petition.
Tomorrow at 2, my lord, if possible, man.
Tomorrow. Because we have already fixed few matters. Okay, we'll list it, we'll see that.
Friday.
Huh?
Friday.
No, let it, we take a chance tomorrow.
Not mine.
Item
No,
53, my lord.
Just tell the court master, I have an assignment, I have to.
Praying for tomorrow, lordship. In spite of.
Tomorrow we are not making, tomorrow we have fixed matters, already
but-
fixed matters.
Small prayer, lordship. My lord, in spite of a lordship order, police called me and arrested me. Whereas case is pending and lordship granted bail and released, they was also complied, lordship. Item 53,
Okay.
in violation of
See,
the
item
order. Item 53,
That
lordship.
tomorrow. And this is Datta's matter. Which was that matter? Item number
37.
37. This 1 or 2 days, there will be difficulty in accommodation.
Lord,
They have that tomorrow, lordship, if
master.
possible, lordship.
Sir, my case
Item
was
53,
listed on-
lordship.
today is the 4th occasion, my lord. Only I have seen minor
You know
modification.
what is happening.
Day
You
after
know
tomorrow,
how-
lordship will.
No, you see today what has happened.
Yes,
We would have
my lord.
disposed of the matter, but we were compelled to pass orders. And the
Yes, my lord.
process, what can we do?
Only my prayer is that lordship will be pleased to my lord dispose this case
Tell the court master.
just after tomorrow.
My lord,
Yeah,
item number 50, my lord, PIT and DPS matter, lordship.
Tell the court master.
Lordship.
We, this 1 or 2 days, we can't accommodate.